It's closing time. Hi, I'm Darren Findling of the Probate Pro. We're going to cover State Court Administrative Order Form PC 591. This SCAO form is PC, which stands for Probate Court. It's 591. It's readily obtainable through the internet, or you're welcome to contact the Probate Pro. We'd be happy to give you one free of charge. With all of these State Court Administrative Order forms, they're created by virtue of a statute or statutes and court rules. In this particular case, the floating arrow is highlighting the statutes or court rules that are relevant to this particular pleading. So let's cover them. The first one is 700.3954. And this statute is a statute that says that you can file the sworn statement to close when it's time to close in unsupervised administration. The personal representative would file this form, and there's no hearing required. So this is a way of closing it without the necessity of having a formal court hearing and without the requirement of having a petition for complete estate settlement before the court. So it's really an opportunity to, in an informal way, close the probate administration by asserting that the personal representative has performed all of their required responsibilities in administering the estate. Now, the other statute is 700.3958, and this statute relates to the certificate of completion. So after this form is filed, then after a period of 28 days have concluded, the certificate of completion form then gets filed with the probate court to close out the probate estate. And that particular form I explained in another video explaining how you complete that form. The Court Rule 5.311 is a court rule that simply talks about the various ways that a personal representative can conclude the administration of a probate estate. And one, of course, is by using the sworn statement to close. So let's work our way through this particular pleading so you know how to fill it out. Now, again, with all of these pleadings, we urge you to work with a probate lawyer who understands how to navigate through this probate process, how to complete the form, and how the statutes and court rules interplay to be assured that you're fulfilling all of your legal responsibilities. Top left corner, you're going to identify the county. Top right corner, the file number. That's the case number assigned to the probate matter. In the center rectangle, you'll see that there's a little check mark in the event that this is a supplemental sworn statement to close. And what that means is if you've already filed this and then additional work occurred and then you're filing a supplemental one, that you check that box. So in the vast majority of circumstances, that if this is of course your first filing, you'd not check that box. As you work your way through the document, at the top it says the estate of, that's simply the estate name. And then here are the assertions that are being provided by the personal representative. First, that you're the personal representative of the estate and that the estate will be closed without a hearing. Again, this is really nice because instead of closing by a petition for complete estate settlement, in which you're asking the court to close it formally with a hearing through a formal process, this is being done informally. But before you can do this, at least 5 months would have had to have expired. And generally within that 5 months is a 4-month creditor period. And that's where Section 2 comes in. Because if required by law or court rule, you publish for creditors. And the reason it says that first part is that there are times that you may not need to publish for creditors. For example, if the statute of limitations has expired for any creditors, you may not publish. But in the most scenarios, you will have published for creditors during that 4-month period, and then after 5 months, you can file your sworn statement to close. Now again, you're asserting that you have fully administered the estate, you've addressed all creditors, you've settled, you've distributed the assets within the estate, and that's where Section 3 comes into play. So if you notice at the end of Section 3, there's a little asterisk. And that asterisk at the bottom of the page speaks to some exceptions to this rule about certain addressing of certain assets and creditor and claims. So it says at the bottom, if any claims remain undischarged, meaning unfulfilled or unpaid, state whether the estate was distributed subject to possible liability with the agreement of the distributees, or state in detail any other arrangements that were made. So really the idea is that if you're not fulfilling your responsibility, you're supposed to make a statement as to those undischarged liabilities. Number 4 identifies that the interested parties are identical to the initial petition. And in the event that they're not, you have to update those people so that the court is apprised of the interested parties throughout the administration. And of course, as you then serve the sworn statement to close, you will have updated the information about who the interested parties that are entitled to receive notice of this sworn statement. As we move further down the document, you'll see that it, in parentheses, check one of the boxes. First one, it relates to deaths before October 1 of 1993. That relates specifically to the change in the inheritance tax laws. Section B says that the person died on October 1 of 1993 or later, and that there's no estate tax due. And this is usually the case in most of these. But again, before you check that box, understand whether the individual's estate exceeded any of the inheritance tax thresholds. Section C says that there is a tax that has been incurred and it has been paid in full. And of course, you would attach to the sworn statement to close a copy of the receipt of that payment, as well as the discharge from the state of Michigan or the IRS that identifies that the debt is no longer owed. But in most scenarios, we're checking Section 5B, the estate, the individual died after October 1 of 1993 and there's no inheritance tax. But again, be careful, make sure you fill this out correctly. Section 6 talks about that you're going to send, or you are sending, this sworn statement to all of the distributees and to claimants, these are creditor claimants, who have neither been paid or may be debarred under exemptions, allowances, or periods of time that have expired under the statute for those creditors to perfect their claim. And if you have questions about creditors, I've done videos on that particular segment, or again, contact your probate lawyer. In addition, it talks about providing a full account in writing to any distributees whose interests are affected by the administration. So for example, if you've distributed, you would have had to have accounted to those family members, to those heirs, devisees, distributees who have a right to receive a distribution. The lower section of the document is a part where the personal representative signs. It also gets notarized. This is one of the few documents in the probate administration that also requires a notarization of the personal representative. So importantly, it can't be signed by the attorney for the personal representative. It must be signed by the personal representative and then notarized. Now again, above that section, I glossed over Section 7, which simply speaks about the reopening of an estate that had been previously closed. Below that, it talks about the interested person's notice. So for example, when this document gets served and sent out to all of the people entitled to it, it tells the people that they have an opportunity to object to this particular document within that 28-day window, or the court may proceed to enter a certificate of completion, which will close the estate. In addition, the statute provides, under the statute we referred to earlier, 700.3954, that if there's a personal representative proceeding and 1 year has occurred, let me state it exactly. Under subsection 2, if a proceeding involving the personal representative is not pending in the court after the closing statement is filed after 1 year, the personal representative their appointment terminates. So this sworn statement to close still gives the personal representative a full year to wind up affairs, conduct business, perform roles on behalf of the estate for 1 year before their role terminates. So this is how you close it informally through an unsupervised administration. And again, you have to understand when you'd want to close it this way versus a court order through a petition that discharges the liability of a personal representative. It's important to understand the difference between these two forms. If you've got questions, reach out to us. This is the sworn statement to close an unsupervised probate administration. At the Probate Pro, we are passionate about probate-related issues. If you have questions about the sworn statement to close or any probate or trust-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.